You're on.
Most people are familiar with our American justice system, the system by which criminals are tried and prosecuted for the crimes which they have committed. However, what many people do not realize is that many criminal cases do not even go to trial. Instead, they are settled in plea bargains. Tonight, I stand in firm affirmation that plea bargaining undermines the American justice system. Tonight, I'll be presenting three main reasons as to why plea bargaining undermines the American justice system. First, plea bargaining is unconstitutional. Second, plea bargaining is not being properly administered. And third, plea bargaining leads to wrongful convictions. Before I begin, I'd like to present some definitions for the benefit of my opposition. First, undermine, which means to erode from the base or foundation of. And second, plea bargaining, which is a deal in which the defendant pleads guilty to a lesser charge or sentence, and in return, the more serious charge or sentence is dropped. Now, there are two types of plea bargaining that it is important to understand in order for someone to understand the issues at hand tonight. The first kind of plea bargaining is charge bargaining. This is when a defendant can accept a lesser charge. For example, in a first-degree murder case, the plea bargain may be to accept second-degree murder. And the second kind is sentence bargaining. This is when the defendant is told in advance what kind of sentence they will get as a result of accepting the plea bargain. For example, if they are charged with something where they can be in prison for anywhere from 5 to 20 years, the plea bargain may guarantee that they will only be in prison for 7 years rather than up to 20. Now, moving on to my first point. Plea bargaining is unconstitutional. Our judicial system is based on the Constitution, and there are many specific instances in the Constitution where it addresses trial. First is in the Fifth Amendment. The Fifth Amendment states that we have the right to not incriminate ourselves, and it also states that no person is to be held to answer for capital unless there has been presentment in front of a grand jury. Also, the Sixth Amendment states the right to a speedy and public trial by an impartial jury. Going to trial is a right that is guaranteed to us in the Constitution, yet coercion and bribery is often used to prevent people from using this constitutional right. The issue of plea bargaining has been brought up in many court cases. The U.S. Constitution, Article 3, Section 2, states that trial of all crimes except for impeachment shall be by jury. Now, in the 1968 Supreme Court case of United States versus Jackson, it had to deal with a statute that stated that the death penalty could only be a punishment if a court was presented in front of a trial, in a trial with a jury. Now, because of this, it created a loophole with plea bargaining, and many people were accepting plea bargains in order to prevent the possibility of them being sentenced to death when found guilty in court. More flaws with plea bargaining can be seen in the 1970 court case of North Carolina v. Alford. In this case, it established that Alford pleas, or guilty but not guilty pleas, were acceptable. These are pleas in which a person claims that they still claim that they did not commit a crime, but they will accept the bargain to prevent more serious aspects from taking place. And finally, in the 1971 court case of Santabella v. New York, it stated that plea bargaining should be encouraged if it is properly administered. That brings me to my second point. Plea bargains are not being properly administered. Even if you believe plea bargaining is constitutional, in its current state, they are not being properly administered. According to PBS, up to 95% of cases brought to federal courts are settled in plea bargains. This means a vast majority of cases aren't being brought before a jury, the facts aren't being presented, and crimes are not adequately being evaluated and punished. Up to 95% of the time, our judicial system is being bypassed. This is clearly not proper administration of plea bargaining. It has become a quick fix, a way for people to save time, instead of searching for the truth and finding out if someone is guilty beyond a reasonable doubt. Charge bargains discourage the truth from coming out by getting someone to confess to a crime that they may have not committed. My third point is that plea bargaining leads to wrongful convictions. According to a Frontline interview with John H. Langbein, what the prosecution says to a criminal defendant in plea bargaining is surrender your right to jury trial or go to trial and you will be convicted of an offense. We will see that you are punished twice, once for the offense and once for exerting your right to go to trial. If stakes are high enough, even an innocent person will plead guilty in order to prevent the possibility of a more serious punishment if they are found guilty by mistake in trial. There's also a conflict of interest between the defendant and their own counsel. Attorneys are paid a lump sum before trial begins, So according to Albert Alschler, once a lawyer has pocketed his fee, it's obviously to his economic advantage to plead the defendant guilty. Because of this, he will make more money by having more time to take on more cases by not going to trial. Even a defendant's own attorney can be persuading him to give up his constitutional right to go to trial, and not for the benefit of the defendant, but for the benefit of the attorney, like I said, so that he can benefit himself. There's also uneven power given to the prosecution, meaning that the prosecution is able to offer a plea bargain and at the same time state that if the defendant does not accept this plea bargain, then there is the possibility of him being charged with a more severe crime than that he is already faced with if he decides to go to trial. The prosecution uses scare tactics to coax the defendant into taking an offer, whether the defendant committed a crime or not, to avoid the horrendous possibilities that the prosecution could exercise as punishment for using his right to trial. Plea bargains don't exist because they're constitutional or because they're a better way of determining guilt than a trial. They exist because they are convenient to the powers of the judicial system. It lightens the workload for judges and both prosecution and defense attorneys. In our judicial system, created by a constitution that requires the government to respect the right of trial by jury, plea bargains are unacceptable. For these reasons, I stand in firm affirmation that plea bargaining undermines the American justice system. Thank you.